Are you worried about seeing a counsellor because you're worried your ex is going to be able to read your notes in court? Do you have a child who is no longer wanting to talk to a psychologist because they've been told that their notes are being read by another parent? Well, today's episode is perfect for you because today we're talking about the changes to the Family Law Act, protecting sensitive information, because starting from the 10th of June 2025, you can now ask the family court to stop certain sensitive information from being seen by others or used as evidence in family court matters. And today we are going to be talking about the new changes when it comes to this in Australia. Welcome, Mum.
Hello, Laura. Hello, everyone.
Now, before we get started, I just want to remind you all that this is general information only. We'll provide the fact sheet that this is based off in our show notes from the Attorney General's website. But Mum is not your lawyer. I'm not a lawyer. And we're not psychologists either, so please make sure you get your own independent legal advice before making any decisions in regards to this.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
All right, Mum, this is so exciting.
It is.
And can you just quickly tell us why this change has been made and how people can use it?
Okay, so this is a change that we all hoped would go through last year when the changes to children's matters and the emphasis on family violence was added to the Family Law Act. But it didn't get through Parliament. So here it is in these new tranche of amendments, which are property amendments basically. But this protecting sensitive information, I think, is just so exciting. It was needed. It was really needed because usually mothers and children were not confident in talking to a counsellor and getting the help that they needed, because this material would invariably be subpoenaed and then dragged through court, and everyone knows what you told your counsellor. So you either held back, or if you didn't hold back and you were really trying to get yourself sorted through the counsellor, then all of that information fell into the hands of the person who probably likes you least in all the world.
And I guess when it comes to it, post-separation abuse, this was one of the big go-to attempt would use with their ex if they wanted to keep stalking them or keep harming them or keep making them feel like they can never get away by subpoenaing their psychologist notes or subpoenaing their doctor's notes, when even if it had no relevance whatsoever to...
Yeah, the one, Laura, where it was after the trial was over, the person issued a subpoena before the orders came out, and there was no reason other than just abuse of the other person and to invade their privacy.
I think it's also really good as a way of, I guess, the government who makes the changes kind of reaching in and reminding the judges how it can affect people's lives and maybe forcing them to consider it a bit more when maybe it's not something that really registers for people who do court every day. How someone reading your notes.
I don't think the court had the power before really to forbid evidence being used in court, or it wasn't explicitly stated. It might have been under 69ZW, I think they had some control. But if your personal information had been subpoenaed by the other side and they said they needed it to further their case, the court would have been at risk if they said no, because it might have led to an appeal. So at least now everyone can use the changes in Section 102 to remind themselves, I guess, about these confidences. Until we see some going through the courts, though, I think we should all be a little bit cautious until we see how the court deals with it.
Okay.
Because, especially in children's matters, because it might be terribly important to find out what you've been saying to a counsellor, what your ex has been saying to their counsellor.
That's where we're going to get into how they determine that. But before we do, it gave some examples of places where you may be able to ask them to keep it confidential. So there's doctors, medical specialists like psychiatrists, private hospitals, day surgery centres, pharmacists, health professionals like psychologists, physiotherapists, occupational therapists, counsellors and social workers, pathology, x-ray services, Non-government services such as phone counselling or drug and alcohol support and fertility clinics are some examples. And then some of the examples of the material that they consider sensitive are things like medical records kept by your doctor, notes made by your counsellor or psychologist, things that you say to a health professional in person or over the phone, records from special services like women's shelters, sexual assault helplines, family violence or support centres, notes made by professionals about talks they have had with your family members or support people. So if your sister talked to you about you, communications between health professionals. So if a doctor wrote to a psychologist or a psychologist wrote to a doctor, and information given when you first contact a service during the administration process, and also prescriptions. So you can now ask, but how do you know if you can?
If you think it would be harmful for the other side to see this information, then you can ask the court. The court will have to weigh it up, though. I can see that, though it seems to me that a lot of those changes are aimed at protecting a person who is abused, children who've been abused, and because they're accessing counselling and other services to deal with the abuse that has been brought on them by the person who actually should be getting counselling, I think that's why this is necessary, because they've realised that it's just, even if it doesn't say anything damaging, it just feels such an invasion to someone to have their private psychologist's records, for instance, brought up in the court.
So the reason is to try to protect you. And the changes, basically, can you just give us in a nutshell what it is that they can do now? What is it that they do?
Well, a court can refuse permission for someone to look at material that they've subpoenaed from your doctors or your healthcare providers. Okay? But the court has to be confident that it's not necessary to the proceedings and the greater harm to them than it would be if they didn't allow the release of the documents. But it's a two-edged sword, Laura. If a person's been accused of family violence, say in a property matter, and they've been getting counselling, right, for the family violence, they may also say that they want those confidences, those sessions, those notes to be kept private. But in fact, it might be a way of proving that there was family violence in the home. And as we know, that's now relevant not only for children's matters, but for property as well. So it's not just the abused, it may be the abuser. So the court is going to be a lot more hands-on about where they get their information from, what they need to look at to verify someone's story or not. Because it's only just come in last month, there aren't any cases that I know of yet that have gone to the appeal court. So we don't know how widely or how narrowly the judges will apply this test. But as I always say, if you don't ask, you don't get.
So basically you're saying that the court can say, no, you're not allowed to look at it. And the Attorney General's fact sheet talked about some things that the court can do. So it's not all just a blanket no. They can allow someone to not see it or photocopy it. They can prevent sensitive documents from being used as evidence in court. They can reject a subpoena. They can not allow a document with sensitive information to be shared. So there's all sorts of different things that they can do. It's not just a blanket ban on the thing together.
Yeah, that's right. And they sort of have some power already. So you can't issue a subpoena yourself. You ask the court to issue a subpoena and they can say no or yes. That was the law always, right? They don't have to issue the subpoena if you don't ask. And always in children's cases, you will see that people are allowed to maybe look at documents, but only usually the independent children's lawyer is able to copy the document. So there's some sort of modicum of protection there. But if you've ever been to the subpoena section of any of the courts, you know that people sit there with dictaphones and read every word onto the dictaphone. So it's not just taking notes. And there's no embargo. There's no way to prevent the solicitors from giving that information to their client and to any barrister.
So if you're interested in you're like, what is a subpoena? You can go and listen to our subpoena episode. But basically it's if you've gone to a psychologist, you've told them everything, poured your heart out, or things that you really don't want anyone to know, and then your ex then subpoenas your psychologist, it means the psychologist has to photocopy and provide all their notes that are specified and asked for within that certain amount of time. So basically then it goes into the court. There's a subpoena document room, and then people can go in who are in the proceedings, so lawyers or your ex, to go in and read the actual notes that your psychologist made about you, or read what you actually said, because these days they use AI transcripts, so it's just word for word what you've said. And those notes can then be looked at and read. So that's what a subpoena is. And then they're supposed to use them in the court case to prove I said this and she said she did it too because she said it to her psychologist, or he said this to his psychologist, therefore he's a bad person. So there's all these different ways people use subpoenas. And if you want to listen to what a subpoena is, go listen to that episode. But basically this is trying to stop people from going in and reading your most personal, deep, darkest secrets if it's not necessary. So, Mum, one of the questions that people ask about this new thing is, how do I know whether I want it to be protected? Should I say, no, I don't want this to be included, I don't want this being shared to everybody in court? How do you know?
Yes. Well, first of all, let me remind our listeners there's a huge fine if the person subpoenaed doesn't provide the document. It used to be $5,000. I think it's more now. So there's a compulsion there. How do you know? I think people are realistically going to use it strategically, and that is if they know that they've said something that might put them in the soup, that might support the other person's case, then I think they may want to suppress that information. It's kind of, subpoenas are kind of like getting to the truth telling. So it's a very important tool. And I expect people will use it negatively and strategically to keep them looking good to the court. So I'm sure people will use that, and I'm hoping the judge will see through that, because when you should really use it, it's when it's going to cause you harm. It's going to be so upsetting but not beneficial to the case. You know, how could your medical records from 8 years ago, for instance, have any relevance on your property matter today or your children's matter today? It may do. You may have been a victim of family violence, or you may have assaulted a child or something. Then it's relevant. But yeah, I think the stuff that you think, oh, I really don't want them to read that. That's the one you ask.
The fact sheet actually says that you can ask, if it's been subpoenaed, you can actually ask if you can inspect it first to decide whether or not you want to stop people. Because you may look at it and it's fine. There's nothing in there that's going to devastate you if everyone knows about it. So that is one thing you can do. You can ask to have a look at it first to make sure that everything's going to be okay. And if it is a subpoena, it says you've got 7 days to object. And we're going to get into how to stop it all in a minute as well. And then let's go into, how does the court decide, Mum? So you've just said it's all about harm. And the family court's main aim when it comes to kids is the children's safety.
Yes.
And when it comes to property, it's to make it go as quickly as possible and as smoothly as possible.
And as fairly as possible.
So what kind of, so they're looking at harm. What kind of harm?
Okay, so it might be harm to you as a parent, that it might damage your parenting ability or set you back. It may prevent you. If this is released, Your Honour, I'm going to be very careful what I say about going to counselling, or I might not go back to counselling now because I'm going to stop getting that because it's coming into the court. That in itself could be a harm to children if you are not getting the help you need to raise your children. So that's one of your arguments you can do. You could say that it is part of a coercive control pattern and abuse. And mostly you'd say it's not relevant or it's not relevant enough. But when it comes to kids, the courts don't particularly worry about your rights or the other person's rights. They're worried about the kids. So I think your biggest trump card is that if it's going to stop you getting the support you need to recover from whatever it is that's gone on so that you can parent properly, I think that would be the biggest harm that I could see.
Okay.
I think the court normally thinks the parents can handle things themselves. But if they've got wind of there being family violence, then that might be the way they look as well. Because interestingly, it's in Section 102 of the Family Law Act, and it's right there with the prohibition on cross-examining a person or being cross-examined by a person when there's been family violence between you both. So I think they have put it squarely in that family violence realm.
Yeah. The information sheet said that even if the document has sensitive information, the court has to decide, and they look at whether you or your child involved in the case could be harmed if the information was shared, or that the harm from sharing the information is worse than the benefit from using it in court. So that's what you're saying, they've got to weigh up the benefit as opposed to the harm. They said you need to tell the court about the harm that could happen if the information is shared. So this might be physical harm, that you may get hurt, emotional harm, psychological harm or oppression, mental distress or stress, harm that affects your ability to care for your child, or financial harm like losing money or resources. I can't even imagine the kind of things that people are subpoenaing to get that, but at least so you can also tell the court why you think the harm is greater than the need to share the information.
Than the benefit, yeah.
So you can also say that if the information is really needed to provide something important that you and the other person disagree about, that the information, perhaps it's already been shared with the other person, so why do it again? So that could be an argument. Or if there's other evidence that doesn't include sensitive information, that could be used instead. So that's kind of things that people need to be thinking about. Now,
I mean, you could always object to a subpoena. You could always object to someone looking at subpoenaed material. That's why you serve the other side. That's why you give it to the other side. But I think this just puts more flesh on those bones and gives the court more power to look at family violence, I think, and its impact on families and children. I think the fact that this was they tried to put this through when they made the changes to the children's orders, where the children's sections now, the best interests of the children are paramount, as they always should have been, and they abolished the presumption of 50-50 shared care. This was the information, these orders they wanted to get in as well at the same time. So I do think it should be easy enough, I think, to make a case about the harm, but there's a reason the law has those scales, because the judge is going to have to weigh it up and walk a very fine line, because a person could always say, well, if only you'd let me look at his documents, you wouldn't have made these orders.
So who can make the application? Who can make an application to protect their sensitive information? Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section, where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today. So who can make the application? Who can make an application to protect their sensitive information?
Either of you or the other person. The independent children's lawyer can. Sometimes the court can do it of its own volition.
Right.
In other words, you don't have to ask it. It might go, look, there's no point to this material. It's just oppressive and it's abusive of the other person. I'm not going to allow that material in to evidence. I'm not going to allow you to see it.
Okay. And how do you apply to get your information protected?
Well, I think you would bring an application in a case. You might also have already put in an objection to inspection of subpoenas, or even an objection to the subpoenas being answered. I think you'll be able to do it orally as well.
Okay.
But an application in a case with a little affidavit telling what the therapy was or what it was that you were doing and what they're trying to get. I think if you use the words therapeutic counselling, so it's non-reportable, that's what you want it to be. It's therapeutic counselling for no other purpose than for my own health, and it shouldn't be part of the court process.
Okay.
I think I'd be saying that, especially with kids as well, Laura.
Mm.
because they need to be able to talk to their counsellors.
That's right. I know, and that's something that people listening today will have to make that decision and the effects that it will have on the children. But perhaps if there's an order that says that it will be kept sensitive and not, then the children may feel better about speaking to someone.
We always had that. The court has for years made orders, not the family report stuff because that's always reportable, but you could ask the court before you even start counselling for the children that to make an order that the children attend therapeutic and non-reportable counselling. In other words, they absolutely can't give any information into the court except what days they went and how long the session lasted, and that's it.
Okay.
So, yeah, you could perhaps put that in your application to start off with even.
What about people who aren't in court and they're negotiating? Maybe they've got mediation, and we always talk about disclosure. And usually we talk about disclosure when it comes to property. But there may be the disclosure we hardly ever talk about is children's matters disclosure.
Yeah, and yet we have to file an undertaking that we've given disclosure about children.
Yeah, so the other side may say, I want to read the notes on the psychologist sessions the children had, or I want to read your notes in your psychologist session before I'll negotiate. Can you try and get around that?
Yes. So you can say it's a bit of a gamble in a way, but you're not in the court precincts, right? You can't ask the court just to make that a protected confidence. What the law is that if in the pre-action procedure stage, before anyone goes to court, there is a document that's called for that you otherwise would have asked the court to protect, which would otherwise therefore be a protected confidence, you can sort of preempt that and go, no, I'm calling it as a protected confidence, and when we go to court, I'll ask the judge to confirm that it's a protected confidence.
Okay.
And remember, the central practice direction says nothing in the whole central practice direction, which sets out your pre-action procedures, nothing in that should be followed if it puts someone at harm, it's at risk of family violence or abuse. Okay. So you've got that protection as well.
It's not the only way you can protect. Is it just through this? Because I've heard you saying, we do talk about it in the subpoena episode, I think, where sometimes there'll be a subpoena for everything you've eaten since 2020 or all medical records ever created in Queensland and New South Wales, or like just ridiculously broad things. Can you try and tackle that? Or if they're just completely irrelevant to the case, do you need to go down this way, or can you just do it something else?
Yeah, you can object to them inspecting any of the stuff that comes back on those subpoenas, but the subpoena itself is between the person, your ex, and whoever it was that they subpoenaed. So sometimes the person they've subpoenaed turns up at court and says, I'm not giving you that stuff, or it's going to cost me $25,000 to get that stuff. And you're just an interested spectator. So you can get involved with the inspection side, but if a subpoena's been issued by the court, then it seems that the court thinks that's probably reasonable. And then if the person subpoenaed says it's not reasonable, then there is a little hearing in the court for that. So I think that it would be a very silly person who issued a really broad subpoena, but they do.
Right.
They do.
So let's just quickly go through a little example then. Okay. So they're heading up. Their mediation didn't work. Mm-hmm. They're heading off to court. Someone's filed an initiating application. Someone's filed a response to initiating application. They're in front of the judge, and someone's asked for. Do they ask for permission for subpoena?
They do. Yeah, they ask for permission now to issue a subpoena.
So they'll ask permission to issue subpoenas to, I don't know, someone's psychologist or the kid's therapist. Do you object then? Or
Yes.
Yes?
Yes, you should object then and let the court know you've got a problem with it.
Right.
Yes.
And so then you've got to kind of tell the judge the reason why you've got a problem with it. And what harm is it going to cause?
Yeah. And the other person has to tell the judge why they want it and what good it would do, how it's relevant, how it's maybe crucial to their case. And then again, the judge in his mental scales or her mental scales will weigh up whether it's worth it or not to bring those in. With children, the mental health of the parents is quite crucial. And so it's going to depend on the circumstances of every case, I think.
And a judge can decide to just do it themselves?
What, stop people looking at it?
Yeah, they can just
Yes.
decide to protect the sensitive
Yes.
information themselves, so that
Yep.
you don't even have to ask. Sometimes the judge will do it on their own bat.
Yes, I wouldn't risk that though.
Yeah.
Because the court usually works on applications from people. But I think it's in there so that people who are self-representing and don't understand that they have the right to do that, I think that allows the court to step in and protect that further harm happening perhaps to the person.
Okay. There's this thing in here in the fact sheet. It says, can I agree to my sensitive information being disclosed or used for evidence? So apparently you can.
Yes.
And you have to give consent in writing or,
And witnessed, I think.
Yeah. Yeah. So the court may want to protect it, but you may want to not protect it.
Yeah. And the court can't protect it if you've agreed to let it go to the other side. It might be in a case, say there's been significant family violence and you've been getting counselling over a long period of time. And in the middle of all of that, there are some disclosures about your childhood and things that, might on first blush appear to be irrelevant. But you want that evidence in of the extent of the abuse and the long time that it's been going on. So you may decide, yes, I'm happy for that too. I'm not happy, but I need that evidence as well. So I want it to be brought in to the court.
So this is really new. So it's come in.
Yes.
I think a lot. I am concerned the fact that they've even got that little question there on the fact sheet. I have a feeling, because we do get a lot of emails and messages from people who've said, I was pressured right at the start. I didn't know what I was signing.
Yes.
It's the same thing as, and we're going to do an episode on this, but family therapy and seeing these kind of third-party expert witness people. I feel like maybe people might get conned into signing an agreement for their sensitive information to be seen. So I hope that doesn't happen, but the fact that it's in there makes me worry that someone may sign something that they don't realise they're signing. So just be mindful of agreeing at any point. Because everyone at the beginning goes, yes, so 50-50, let's do that. I won't touch the super.
Let's not touch the super.
Let's expose all our sensitive, confidential information. So that may be a new pressure point that is put on people, especially in family violence situations. So I'm just mindful of that to anyone who's listening.
I think the court tightened up its rules about who can write a report. That was the second sort of prong of this legislation. And it's not permitted for, perhaps if you've agreed to go to family counselling or family therapy, and my views on parenting coordinators and all that, if you've agreed to go, the court says they can't file a report. They can't put a report in without the permission of the court, and I don't think they'll give it very often. So that's going to stop these sort of, it's really, sometimes you'll have a family report and then you get a counter family report that has a different point of view. And maybe the other side runs around and gets 3 different counter reports, and they've been filing them, which kind of undermines the concept of a single expert witness. So they've tightened up those procedures in the court as well. But when you make legislation, as the government has, you're really looking into a crystal ball and saying, I hope this works out the way we think it will, but humans being humans will find ways around it. But I'm hopeful, Laura, I'm hopeful. Given that the Attorney General turned around and said, after 17 years of everyone thinking equal shared parental responsibility and 50-50 for children was what the legislation said, they turned around and said, no, we didn't really mean that to happen. That wasn't what we meant.
Yes.
So I think in time, as we get different judges' results through these things and we get a couple of appeals about information that's been suppressed or released, gradually there'll be guidelines developed. Okay. And gradually you'll know the personality of your judge, whether they're more inclined to suppress or more inclined to let it in.
Right. So really today was just a little overview summary of the protected confidences. So we've looked at what types of information can be protected. That's pretty much anything, but a lot of medical, psychological, health-related issues. Who's allowed to ask the court for the protection? There's a whole bunch of people. The court can do it themselves. The independent children's lawyer can. You can. some other person in part of the process can, how the court will make those orders, so you can go through your application when you first file in court to ask for the protection, or you can do it as an application in a proceedings. Or Mum, you said application in a case. Is it the same thing?
It's the same thing. They just changed the words.
So you can ask, what kind of thing would you ask what kind of order would you ask for?
Off the top of my head, I'd say something like that the parties or that the respondent is restrained from inspecting the subpoenaed material from Dr. such and such in relation to the one. It might be that the respondent and his lawyers from time to time are restrained from inspecting and also restrained from using that information.
Right. So go and see a lawyer and get the right wording for the reason you want to do it, because you've got to get the judge then. The next step is to agree to that order and make that order. And the court has to weigh up why are you wanting that? What's harmful about it? And then weighing up whether it'd be better to have the information and the evidence for the reason for the case. So you've got to do that weighing up. So really it's important to see a lawyer to help you come to that conclusion and make sure you make that pretty strong in your case.
And I think the answer might be different at different stages of the litigation. So it might not be relevant. You might say I'm going to say it's a protected confidence while we're negotiating because it's not relevant here. You might, even on an interim basis, the judge may say, look, I'll put an injunction on the respondent and their lawyers from looking at it, but I'm not going to order that the documents be destroyed because I may revisit this as further down the track if, something or other happens, or if the independent children's lawyer thinks it's the right thing to do. So it might be that they're more often going to let it in at a final hearing rather than early on in the case, because I know that the court is anxious not to fuel the flames of the dispute between people in the early stages, because if you can settle without ever having written an affidavit that sets out what you really think, then the chances of everyone getting along reasonably after that are much better than if you throw the kitchen sink at them on the first court date.
So do you think psychologists are going to be across this? Do they need to be across this?
No. No, they need to just know if they're subpoenaed, then they may have to object. They can go to court and object and take their own lawyers or whatever, or they can honour the subpoena, bearing in mind that very hefty fine for not complying. So they don't need to be across this. This is between you and the judge and the other person.
And is it potentially a proof or more evidence of coercive control family violence if they are constantly subpoenaing and constantly trying to pry into your life when it's not relevant?
Well, it's a bit hard to say that because they may not know it's not relevant until they get the material. They may think there's some wonderful, important point there, and then when they get it, it isn't there. So I think people are entitled to look for the evidence that supports their case. So it'd have to be in a particular circumstance if a person just keeps banging on about it, because I know that the first time someone's psychologist gets subpoenaed, that's probably the last time they tell the psychologist everything, or it may be the last time the psychologist takes detailed notes.
And But that example you gave of where the person subpoenaed after the trial, I guess that's an example though, right?
Yes.
Yeah.
And they were untouchable because the case was over. It was just meant to upset the other person.
And just
if it ever goes back to court, that would be a very interesting point for that person to make.
And I guess just the thought of if you are in an abusive relationship or you've escaped coercive control, and if you have, please consider calling 1-800-RESPECT or calling 13 11 14 Lifeline to get the support. And I know that 1-800-RESPECT is now recommending people listen to our podcast. We got an email yesterday.
Are they? I didn't know that.
I called 1-800-RESPECT and they told me to listen to us and see what resources we have available. So thanks, 1-800-RESPECT.
Oh, wow.
But I think if you're experiencing that, the last thing you want is your ex to be sitting in that room looking at your documents and just enjoying being a stalker.
Yeah.
So I guess this is going to help people to get the support they need without being terrified of being followed and stalked and continued, like, because there are people who are obsessed with new relationships. Who are they dating now? Where are they going?
Yes.
All that information would be in a psychologist's discussion, I guess, if you talking about that.
Yeah, but also too, there might be stuff in that information that you've told your psychologist that you would never dare tell your ex because you're so afraid. And yet they're going to find out. If you knew they were then going to find out, and you can't go back and change what you've said, can't change the psychologist's notes. So it can cause, I'd go so far as to say it can cause terror in someone. And I would also go so far as to say that the person who subpoenaed those records, if they've been that sort of person, they know very well the power and the distress that they wield.
The other thing I think, Mum, is they've got to weigh up, yourself, not the judge, but you need to weigh up. Are you going to object to it? Because maybe you need that information as proof that you've gone through family violence, or you need that information to prove something, because especially now that family violence can be considered
in property.
In property, and it can affect your percentage. And if you're interested in listening to those changes, I'll put a link in the show notes to that episode. But yeah, so you now also have to weigh up, well, yes, it's mortifying and I don't want them to do that. But on the other side, it's kind of my evidence.
Yes, and it's interesting. It'll be interesting to see how courts get around that. I haven't heard of anything about redacting, where you might black out certain bits. The court is used to that in subpoenas, because if you subpoena one of the child safety departments, for instance, they'll often, the names are blacked out of who the informer was and so forth. But yes, it's going to be a very interesting situation watching how that develops and what practices the court develops so that they can achieve that purpose of protecting people who've come out of family violence relationships and protecting the children so that they can get the help they need, while at the same time putting the best interests of the children to their top of their mind. And it may be that the court may say, as you may say, as a person who's the parent, it's going to be awful, but I do need to reveal this so that the court knows the right thing to do for my children.
Because I was thinking about, and we're doing an episode next week on family reports and psychologists and, all of that kind of stuff, child impact reports, etc. And when it comes to child impact reports and when it comes to family reports, the children are told this is going to be shared with both your parents. So the kids know straight off the bat that whatever comes out of their mouth is going to be shared with both parents. So it may not ever be, kids are smart, and if kids have been in a relationship where there has been violence, they know to keep their mouth zipped and locked if someone says that. But they may have said it and talked about it with the psychologist. So you may need that information to help your case. But then there's that delicate balance of if you do use it and the children are told that your notes have to be shared with the court, is that going to stop them from ever getting counselling again, or is that going to stop them from ever getting the support they need? Because it's a really hard decision that you're going to have to weigh up. And I guess one of the things you could do to make that decision is not only talk to a lawyer, but talk to your psychologist, talk to the kid's psychologist. Ask them, what do you think the effects are going to be? What have you seen happen in the past from other children when their notes have been subpoenaed? How does it affect them? How do you think it's going to affect my child? What do you think the best decision is? And because sometimes, like you said, Mum, the notes that psychologists take aren't particularly detailed when it comes to children because they're playing with puppets or colouring in. It's not really much said in a session. So is it worth breaking that confidence? Is it worth it? And I guess you've got to decide that, but also the court has to decide that. It's a big, horrible thing to think about, but at least you've got the option now to think of asking. Whereas in the past, it was just a blanket tough luck.
And, the person who is insisting on the release of the information, even if they're unsuccessful, it says something about them, that in the face of your arguments about the best interests of the children, that they don't care. They just want that information out. And of course, we have to be careful that whatever the children say, if it's released to the other parent, what if the court still orders them to be going to the other parent? And what if the other parent is volatile? So I know those are the things that swirl around in people's heads. Like if little Johnny says this, how's that going to play out when they go over? Especially if you've got someone who's a little bit obsessive. So we put a lot of stake, I think, a lot of faith in our psychologists and other family report writers to see through a child's reticence and the kind of put on, posy behaviours. We put a lot of faith in them, and a lot of them are very experienced, but sometimes some people are very clever and it doesn't get taken into account. So,
and oh my goodness, whoever
tricky.
is listening to this and has gotten to the end of this episode, obviously you're going through hell or about to, and there's nothing pleasant about subpoenaing people's information. There's nothing pleasant about somebody's random lawyer that you don't even know reading your information.
Yes.
And there's definitely nothing pleasant about it being read out in a witness box or to a judge in front of people. It's horrific. It's horrible. I hope that maybe this brings you a little bit of hope. And if you are with a legal aid lawyer who's just going to help you on the day, bring this up. Remind them. They might not be aware of it. This is brand new legislation. Some lawyers might not be aware of it. Print out the fact sheet, download it off our show notes and take it with you if there's concern for you. But really, I think you have to sit down and have a little think and talk to some professionals. Do I need to try and protect this or do I not?
And for anyone who's been through this and it's too late for them, we feel for you. But I think what has happened to you and many, many other people before you has led to the government making this change. So you can feel a little bit better, I guess, knowing that you have helped anyone else coming through that same process.
And if anyone is suffering from legal abuse, which I believe this is trying to stop, you can go listen to our Divorce When It's Not the End, where we talk about post-separation abuse and legal abuse and what you can do about it. And we'll put that in the show notes. Wishing you all the best. Mum, thanks for helping us get our heads around this new change.
Thanks for having me, Laura.
If any listeners are out there, I'm going to put up a poll on Spotify, if you're listening to Spotify, on whether or not have you considered protecting your confidences? Are you going to be requesting sensitive information to be held back, yes or no? We'll put that as the poll.
It's anonymous.
Yes, it's anonymous, so you can just do the poll. And if you are interested, as Mum always says, we love it when you give us reviews because it helps the algorithm send our podcast out to others who may be also struggling in the dark in a trial or leading up to court. So please give us a review or even just 5 stars and help us get out there a bit more.
And on YouTube as well, if you share and if you haven't subscribed, if you subscribe, I think of it as kind of paying it forward. And hopefully we'll start to see some real change.
Yes. So we'll see you all next week. Thank you, Mum, for your time. And thanks for everyone for listening.
Bye, everyone.
Bye.
All the best.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.